In this video, I'm going to take time to talk to you today about default and foreclosure under Article 9 of the U.C.C. At the outset, it's important to understand that anytime a debtor and creditor contemplate entering or consummating a debtor-creditor relationship under Article 9, that it is imperative for the creditor at the outset to define in their security agreement all the events that will trigger default. And those can be numerous, and those can be strictly defined by the creditor who has the upper hand in defining any debtor-creditor relationship. First, events of default could include the following, just to give you some examples. Non-payment for a stated period of time. For example, if you get 30 days behind on your payments, or 60 days or 90 days, that could trigger default. So these things can be defined in the security agreement. Other examples might include things like the following. If there are situations or events that give the creditor fear that the debtor might become insolvent or that they're heading towards bankruptcy, that could be defined as an event of default. For example, it could be other things like, for example, filing of a state or federal tax lien against the creditor. That could be the debtor. That could be an event of default. It could include other things like non-payment of property taxes or non-payment of insurance premiums on the collateral that forms the basis of the secured debt between the debtor and the creditor. So default is important to define at the outset for the creditor. All events of default should be strictly delineated and articulated in the security agreement between the two parties. When you do get into the situation where a debtor defaults, there are usually three options that the creditor can pursue. Number one, the creditor can pursue a strict foreclosure. For example, let's just say I am a business owner, a debtor, and I come to your bank for financing, and you take out a security agreement or interest in all of my equipment, and for whatever reason, I don't pay you back, and now I've defaulted on my debt or my obligation. You can come in and repossess or foreclose on my equipment if that has been what I pledged for you as collateral to extend credit to me in the first place. So that's one option that the creditor has. The creditor can come in and strictly foreclose on the collateral. Now, when they do this, and oftentimes they do it at the consternation of junior creditors, when the senior creditor comes in and forecloses on the collateral and they do a strict foreclosure, they are cutting off other remedies that they might have. Ideally, these things are only done, or they're done most often in situations where the value of the collateral exceeds the debt. So strict foreclosure is one option that the creditor has. Another option that the creditor has is to pursue a private or public sale of the foreclosed collateral. Now, ideally, when this happens, the creditor is trying to recoup or make good on all or at least a part of their debt as they sell items of collateral in either a public or private sale. The important thing about a public or private sale is that it must be done, number one, with notice to the debtor or obligors of the debtor. You have to give them notice ahead of time if you're going to conduct a private or public sale. And secondly, the private or the public sale must be done in a commercially reasonable manner. So commercial reasonability is the standard. If you hold a sale and it's not been advertised, or you haven't taken other steps to preserve or protect the foreclosed item or collateral or asset, then your actions might not be commercially reasonable. If I only give 3 days notice ahead of the sale and only 1 or 2 people show up, it's probably likely that a court would say that my actions aren't commercially reasonable. Now, it's important to remember that the commercial reasonability standard is judged on a case-by-case basis, and it is really fact-specific in each case under each unique set of circumstances when the creditor is going out doing a foreclosure and doing a sale, whether it be private or whether it be public. In any sort of sale, oftentimes there's going to be a situation where the collateral, when it's sold at a public or private sale, doesn't fully cover the collateralized debt obligation. So there can often be a shortfall or deficiency. Let me just give you an example. Let's just say that the debtor owes me $100,000 and they pledge all of their equipment to me. And they've defaulted on paying their obligation to me. So I go in and I foreclose upon their equipment and I sell that equipment off. And after doing everything commercially reasonable and engaging in a public sale to the highest bidder of that collateral, I only net $75,000. Well, I still want to get $25,000 to pay off the remaining debt of $100,000 that I'm still owed. So what's my next option? If I'm the creditor, I can foreclose and sell the item in a public or private sale. And then I have the additional option of being able to go after the creditor and sue them for the deficiency. So I can seek and pursue a deficiency judgment against the debtor. So that's an important option and right that the creditor has at their disposal. Now, there's another avenue that sometimes arises. There's sometimes situations where the stars line up perfectly, and as a creditor, you are oversecured in the collateral that you have a security interest in with a given or particular debtor. These are rare occasions. Not to say that they don't ever happen, but they are rare occasions where sometimes there can be equity in the collateral that you have a security interest in. Let me just give you an example. Let's just say I go out to a commercial bank to get a loan to operate my business. And I want a loan for $100,000 to give me a little operating cash to go out and pursue new business opportunities. So I go to First State Bank and the bank decides that they're going to give me the $100,000 that I want. And I have equipment that is really valuable that I use in my business. And I pledge this equipment as collateral for this particular debt. And let's just say the stars line up. The equity that I have in the equipment makes it worth $250,000. So you see the math there? I've gotten a $100,000 loan from the creditor, First State Bank, but my collateral that I'm pledging, my equipment, has a market value of $250,000. So there's an upside for the creditor to extend this loan to me because they're oversecured. There's a margin of $150,000 if anything goes wrong and I don't pay them back. Let's just say the facts do indicate that I don't pay back my debt obligation of $100,000. I go into default soon thereafter after I get the $100,000 loan. So the creditor, First State Bank, they can come in, they can seize my collateral and decide to foreclose upon it, and they can sell it off at a public auction. Let's just say they sell it off at a public auction and they net $225,000. Well, what happens to the surplus? Well, they would have made good on their $100,000 debt, but there would be $125,000 minus expenses. You got to consider if they spent time going out getting an auctioneer, they had to hire an attorney or an appraiser to evaluate the property or to take other steps, any necessary expenses, they can deduct those expenses from recouping their debt. But on the other hand, let's just say we're left with $100,000 left over. In that situation where there is a surplus, it is the duty of the creditor to pay that surplus and hand it over to the debtor. So it might not be a total loss to the debtor if their inventory is seized in this sort of manner. So these are the methods and the rights that a creditor has on default. They can pursue a strict foreclosure if they want to, and they walk away, they just seize the collateral, and that's the end of the story. Or alternatively, the creditor can sell off the collateral in a foreclosure sale, either a public or a private sale, and pursue a deficiency judgment. And in those rare circumstances, there might be a surplus. And again, in that situation, if there is a surplus after a foreclosure sale, the creditor is obligated to pay over or hand over the surplus to the debtor. I hope that you found this video helpful as you figure out the remedies and the rights between debtors and creditors. Thank you for watching.